Palestinians in Gaza, as a very substantial and important part of the Palestinian national, racial and ethnical group, simply but profoundly are entitled to exist. As South Africa's ambassador pointed out in opening, to situate the right to exist and the threats to that right requires the court to appreciate that this application by South Africa is brought within a particular context. What is happening in Gaza now is not correctly framed as a simple conflict between two parties. It entails instead destructive acts perpetrated by an occupying power, Israel, that has subjected the Palestinian people to an oppressive and prolonged violation of their right to self-determination for more than half a century. And those violations occur in a world where Israel, for years, has regarded itself as beyond and above the law. As the UN Special Rapporteur on the occupied Palestinian territories explained in 2022, and I quote, "The occupation by Israel has been conducted in profound defiance of international law and hundreds of United Nations resolutions with scant pushback from the international community." That context is important, as South Africa made clear in its application. Where the international community has failed Palestinians for so long, and despite Israel's willful defiance of Palestinians' rights, South Africa turns to this court, seeking to protect the core rights of Palestinians in Gaza, to be protected from acts of genocide, attempted genocide, direct and public incitement to genocide, and complicity in and conspiracy to commit genocide. As the court knows, the Convention prohibits the destruction of a group or part of that group, including through killing, causing serious bodily and mental harm, and inflicting conditions of life calculated to bring about the group's physical destruction. Through these core rights, the Convention further protects the rights of its members to life and physical and mental integrity. Palestinians in Gaza, women, men, children, because of their membership in a group, are protected by the Convention, as is the group itself. And the core rights are violated and threatened by a remarkable set of facts outlined by my colleagues and set out in detail in South Africa's application with supporting evidence. In the speeches to this court today, South Africa has chosen, as you've heard, to avoid the showing of graphic videos and photos. It has decided against turning this court into a theatre for spectacle. It knows, as well as your excellencies, the temptation for both sides in a dispute to parade pictures to shock. But South Africa's application in this court today is built on a foundation of clear legal rights, not images. The detailed material before the court is marshalled to show a case for provisional measures based firmly on this court's prior decisions, and South Africa advances its case on the basis that Palestinians' rights are equally as worthy of protection on the unprecedented evidence before you as those of the victim groups that this honourable court has previously protected by its issuance of provisional measures in the past. The material confirms the rights in issue and their violation, that Israel has committed and is committing acts capable of being characterized as genocidal. You have heard from Ms. Hassim about direct extermination of thousands of people and children of the Palestinian population in Gaza since 7 October last year. And South Africa and the world together stand witness to the forced evacuation of over 85% of the population of Gaza from their homes, and the herding of them into ever smaller areas without adequate shelter or medical care to be attacked, killed and harmed. So, the rights are immediately and urgently in need of protection because of the ongoing denial by Israel of the conditions necessary for life.